Hey everybody, we are back in the shanty, and I know what you're thinking. No shanty forever, and now two in like a week. Why two in a week? Well, let me tell you why two in the week. Two in a week because the Michigan Court of Appeals just issued its opinion in the Mothering Justice case. For those of you that don't know what the Mothering Justice case, you do know what it is. You just don't know it by that name. It's the case where they were deciding whether or not the Minimum Wage Act and the Michigan Paid Medical Leave Act were unconstitutional and were overturned, and where the judge in the Court of Claims said that the way those laws were put into place was unconstitutional, and that therefore the Earned Sick Time Act, primarily for your benefit, and the Minimum Wage Act would go into effect on February 20th. The Court of Appeals is making me look bad because I've been saying all along there was no chance that these things were going to be overturned. And the Court of Appeals overturned the Court of Claims. And they have been overturned. So, hard stop on whatever you're doing to change your sick time policy. And we're back to the Michigan Paid Medical Leave Act, and we're back to the minimum wage the way it was. So what did the court say? All right, so we start out with what the Court of Appeals said the issues were. And I'm going to do a lot of reading in this one. They issued a 20-page opinion. There was 2 concurring opinions. That means every judge on the panel wrote an opinion. I'm not going to talk about the concurring opinions. I'm only going to talk about the majority opinion in this shanty, and I'm going to do it very quickly because I know the phone is going to start to ring very quickly. So the court framed the issue this way. The issue we must decide in this expedited appeal is whether 2 statutes that were enacted by the legislature under the initiative process outlined in the state constitution can be amended during the same legislative session in which they were enacted. The Court of Claims held that the legislature was prohibited from doing so and thus ruled that 2018 PA 368 and 369, that's the Minimum Wage and Michigan Paid Leave Act, were unconstitutional. Because the trial court's conclusions are not supported by either the text or the intent of Article 2, Section 9, we reverse the Court of Claims order and remand for entry of an order granting the state motion for summary disposition. The court just overturned what the Court of Claims did, and we are back to the Michigan Paid Medical Leave Act. Now, the court also made a couple of interesting observations that I want to point out to you. They said, first of all, before turning to our discussion, we reluctantly add a disclaimer to emphasize a point we hope is obvious, but we know is often lost by those who focus solely on the results of a court decision rather than the analysis within that decision. The underlying policy set forth in the public acts at issue are completely irrelevant to our decision. So what the court's saying there is, we're not opining on whether the Earned Sick Time Act or the Michigan Paid Medical Leave Act are good statutes or bad statutes, whether one is better than the other. We don't care. We're only going to talk about the Constitution. And then the court went on to cite the constitutional provisions. And obviously they did a bit of a deep dive into those provisions. And their deep dive during their deep dive analysis of those constitutional provisions, they made an interesting observation regarding the difference between the United States Constitution and a state constitution like the Michigan Constitution. And here's what they said about that. A different rule of construction applies to the Constitution of the United States than to the Constitution of a state. The federal government is one of delegated powers, and all powers not delegated are reserved to the states or to the people. When the validity of an act of Congress is challenged as unconstitutional, it is necessary to determine whether the power to enact it has been expressly or impliedly delegated to Congress. The legislative power under the Constitution of the state is as broad, comprehensive, absolute, and unlimited as that of the Parliament of England, subject only to the Constitution of the United States and the restraints and limitations imposed by the people on such power by the Constitution of the state itself. That's an interesting observation about what this court panel views the difference between the U.S. Constitution and what a state constitution is. Now, I don't know if in practice the courts have interpreted the U.S. Constitution the way they have, because the commerce power under the U.S. Constitution is interpreted as being pretty broad. But nevertheless, it's an observation that the court made, okay? And it's an interesting observation probably for lawyers and constitutional scholars, but maybe not so much for you guys, so I probably shouldn't even be spending time on it. All right, so then the court framed the question. After they did their analysis and their deep dive into the constitutional provisions, they framed the analysis of the questions, and they framed them this way. The disputed question, of course, is whether the legislature could amend those public acts after the 40-day period expired. There's a 40-day period that they had to wait, but prior to the end of the legislative session. As has been said before, this issue is not without difficulty. However, for several reasons, we conclude that the legislature acted within its constitutional authority when it amended PAs 337 and 338. And then they give the reasons why they think that. And there's 5 of them. First, focusing on the common understanding of the words employed within Article 2, Section 9, the commands placed on the legislature were satisfied by adoption of the initiative proposals in full within 40 session days of their submission. In other words, when they were taken to the court and said, the legislature, and said, we've got enough signatures for these to go on the ballot, the legislature had 40 days to adopt those initiatives, and they did that. They adopted them within 40 days. Second, although Article 2, Section 9 contains a provision precluding the legislature from amending certain laws until the next legislative session, that restriction is specifically and only for laws subject to referendum. That same restriction, which the trial court essentially imposed upon the legislature for initiatives as well, was not placed by the people on initiative laws. In other words, the court said the logic that the Court of Claims used to get to its decision was wrong, that they misread the language of the Constitution. Third, the Constitutional Convention record shows both that the framers envisioned the legislature taking full control of legislation by adopting it, and specifically rejected making the legislature wait until the next legislative session to amend voter-approved initiated laws. So what the court says here, and you'll see this in the opinion if you go back and read it, because there's lots of quotes from people during the legislative enactment of the Constitution, that the history of the Constitution shows that what the Court of Claims found illegal was specifically not in the minds of the people passing the Constitution. In fact, they felt exactly the opposite way. Fourth, in the absence of any restrictions, the legislature is empowered to amend any law. And our case law states that an initiated law enacted by the legislature is on the same footing as any other law passed by the legislature. In other words, once the legislature adopts the law, the initiative, they can do anything they want with it. They can amend it whenever they want. And then fifth, construing Article 2, Section 9 as not prohibiting the adopt and amend procedure does not interfere with any other constitutional provision, and particularly the right to a referendum on the initially adopted laws. And then they say, we explain our reasoning below, and they go into detail to explain why they decided what they decided. But the bottom line is this. The court held the opinion and order of the trial court is reversed, and the matter is remanded for entry of an order granting the state defendant's motion for summary disposition. So what does that mean for you guys? Well, I'm going to quote from one of our appellate lawyers. His name is Gaten Derville-Reich. I probably butchered his last name, and I really apologize, Gaten, if I butchered your last name. But people do it to me all the time. With respect to the old minimum wage law and the Michigan Paid Medical Leave Act, which now, as a result of this opinion, go back into place, Gaten says this, quote, that means nothing will change with these laws unless plaintiffs appeal to the Michigan Supreme Court and the Michigan Supreme Court takes action, or until the legislature moots the whole case by amending these acts on its own, which is a distinct possibility. You can bet plaintiffs will appeal this to the Michigan Supreme Court. And Gayton says this, and that bench has a different bent than the panel we just had. But for the time being, clients can rest easy. The Michigan Supreme Court appellate process and workload is such that it is unlikely to rule before next winter, if at all. And then Gayton says, I'll keep you posted on important developments in the proceedings as the next appellate stage unfolds. End quote. So what does that mean for you guys? Those of you that have written new policies, you could put a hard stop on that and go back to the old policies. Those of you that haven't started writing your policies because you were waiting to see what was going to happen, turned out to be a pretty good gamble. You could just stay with your old policies. If you're in compliance with the Michigan Paid Medical Leave Law, which all of you should be now, you're good. If you have any questions, and I know you're going to have them, reach out to your Warren Norcross and Judd labor and employment lawyer, and we'll get those questions answered for you. Thank you very much. See you next time.